Hello, teacher and everyone. We are Group 5 and we're gonna present Chapter 17 on the corporation law. So before moving forward into knowing about the law and legislations about corporations, first we need to know about the administrations of the corporation are generally each country will have different departments who are responsible for the corporation law and legislation system. For example, in Australia, it is the Australian Securities and Investment Commission, the ISAC, who has sole responsibility for the administrations and enforcement of the Corporation Act nationally. It is an independent statutory commission, and in exercising its functions and powers, the ASIC is subject only to a written direction by the responsible Commonwealth Minister about the policies it should pursue and priorities to be followed under the national scheme. And in terms of Vietnam, the National Assembly promulgates the enterprise law. This law regulates the establishment, management, organization, reorganization, dissolution, and related activities of enterprise, including limited liabilities companies, joint stock companies, partnerships, private enterprise, and regulations on group companies. Now let us talk about the nature and formations of companies. So to register a company, a person first must log an application and pay the required fees. Second, the contents of the applications as set out in a given document by the ASIC or National Assembly of Vietnam is different. And after having done the required procedures, a company come into existence as a body corporate at the beginning of the day on which it is registered. And here in the slide, you can see the 6 key features of companies. They are: first is separate legal personalities. The second is limited liabilities. The third is flexible ownerships. The fourth is the rising funds. Next is flexible governances. And the most important one is the tax rate and breaks, which state that companies are taxed at a lower rate than individuals and have more tax breaks. Then we move to the part of corporate personality. So basically, first, upon incorporation, a company is a separate and distinct legal person. It has an existence separate from the holders and its shares who are its members. The acts of a company are its acts, not the act of the members. Furthermore, its assets and property belong to it, not its members. And also, the section 143 expresses this principle of the separate legal identity as a company has the legal capacities and powers of individual both in and outside this jurisdiction. So let's look at a case in this section, which is between the Salomon and Salomon Limited companies. So the facts in the case that it is Jeff Salomon transferred his business of bookmaking, initially runs as a solo proprietorship, to a company with name as the Salomon Limited Companies, incorporated with the members, including himself and his families. The price for such transfers were paid to Salomon by the weight of shares and debentures having floating charge, which is the securities against the debts on the assets of the company. And later, when the company's business failed and it went to liquidations, Salomon rights of recovery the secure through the floating charge against the debtors stood prior to the claims of unsecured creditors who would thus have recovered nothing from the liquidation proceeds. To avoid such other unjust exclusions, the liquidator, on behalf of the unsecured creditors, ordered the company was initially an agent of Salomon, and therefore Salomon, being the principal, was personally liable for its debts. In other words, we could say that the liquidator sought to overlook the separate personalities of Salomon Limited Companies, distinct from its members, Salomon, so as to make Salomon personally liable for the company debt if he continued to conduct the business as a sole trader. And after knowing about the background and some facts in the case, now we will look at the issues and the court view in the case. For the issues in Salomon and Salomon Limited Companies, the case concerned claims of certain unsecured creditors in the liquidation process of Salomon Limited Companies, a company in which Salomon was the majority shareholders and accordingly was sought to be made personal liable for the company's debt. Hence, the issues was whether, regardless of the separate legal identities of a company, a shareholder or controller could be held liable for its debts over and above the capital contributions so as to expose such member to unlimited personal liabilities. And from the court view, the first one, the court of appeal declaring the company to be a marked originate that Solomon has incorporated the company contrary to the true intent of the company's act in 2000 in 2862 and but that the latter has conducted the business as an agent of Solomon who would therefore should be responsible for the debt incurred in the course of such agents. However, from the views of the House of Law, however, upon the Court of Appeal reserved the above ruling and held that the company's what duty incorporated and it is independent persons with its rights and liabilities appropriate to itself, and that the motives of those who took part in the promotions of the companies are absolutely irrelevant in discussing what those rights and liabilities are. Thus, the legal fictions of company between the companies and its owners or controllers were firmly created by the Solomon case. Coming up next, we will talk more detail about the features of a company's some of the main resulting from the incorporations of a company limited by shares are as following. The first one is that the liabilities of the members is limited. For easy understand, for example, a shareholder with 100 shares issues at $1 each share cannot be made to pay more than $100 represented by the shares. When the full $100 is paid for the shares, the member had no further liabilities to the companies or its creditors. And the second is a member may transfer their interest in the companies by the comparatively simple procedures of executing a formal transfers of shares. This means that the transferee, which is a person to whom the shares are transferred to, takes them subject to the same rights and liabilities as the transferor, which is the person by whom the shares are transferred. And the other remaining features we can skip quickly, which is the permanent existences, the contracts, and the constitutions. And to end up my presentation part, I will come up with the questions. Which types of companies that may be registered? And in this part, we will discuss about four types of the companies. So first of all, it is the company limited by share, the most common types of corporate structures in which the companies issue shares to raise their capitals. So it is very easy to see such kinds of the companies in the daily life. Since like Amazon, Starbucks, or Vingroup, they are the examples of companies that are limited by shares. And secondly, it is the company limited by guarantees. These companies do not have share capitals. They therefore have registered scope and are usually found in the non-profit sector, such as the sport club or the NGOs. Such companies are formed on the principle that the original guarantors of the companies undertake to guarantee the payment of a certain sum to be used to pay for the company debts in the event of the company being grown up. Their liabilities is limited due to the extent of the amount guaranteed. And the third is unlimited companies. This means the companies formed on the principle of having no limit placed on the liabilities of its members. The holders and shares have no limit on their liability to contribute to the assets of the companies in the event of it being rolled up, and consequently, they can be called upon to pay any amount of necessary to discharge the liabilities of the companies. So few company of this type exist in the daily life. And the last one is the no liabilities companies. This last of company may be formed only for the purpose of mining on the principle of their member incurring no liability to pay the cost. And this is the end of my part. In the next part, Loon will talk about how the company making the contracts.
Administration of the Corporation Act. Now I'm going to give some more details about how you can apply this law into the contracts with the third party. So as you can see in this diagram, contracting with a third party is not a piece of cake. There are many ways to make contract with a third party, and each requires distinctive application of the Corporation Act. So in general, third party is not only someone coming from the outside of the company, but even in the within. The officers and the other agents of the company have power to be in the company in person. They will a company are entitled to make certain assumptions. These certain assumptions has the purpose to increase the protection for third parties by limiting the circumstances in which a company may argue that it is not bound by the contracts because its agent was not authorized to enter into such contract. So, which means these assumptions are cumulative and may cure deflects in formal execution process. So, you may know that this law covers law of possession and subsections, but the two main sections today that I'm going to give more focus on is sections 128 and 129. So I know that there's a lot of work to go through these two sections, but in general, section 128 is the entitlement to make assumption in section 129, or in other words, it will point out the circumstance or the conditions in which section 129 can be taken into account. And as a result, sections 29 with 6 subsections will lead us to certain assumptions that the third party can make in accordance to the significance of section 128. There are a lot of words right here, but don't worry, I will not go through all of them. But I'm going to give you another look, the application aspect of this section into a real case. So the case I'm going to present here is between Hodgson and Waller in 2016. To fully understand this case, we have to date back into 1998, when 1996, when the directors of a bench request, Mr. Hodgson and Mr. Waller, has personally guaranteed in an overdraft facilities provided by the ANZ. This personal guarantee was later used as a security for the 29 loan. The further security for the repayment of the 29 loan was given to ANZ by the way of mortgage over a rural property owned by Mr. Waller. The Adventure Quest defaulted under the terms of 29 loan, and in 2014, the ANZ commenced recovery proceeding against Adventure Quest along with Mr. Hudson and Mr. Waller as the guarantor. The relief claimed by ANZ in the recovery proceeding included leave to issues rights for possession of the property. So exactly which is the issues rising here. The issues that have to be dealt with here is that Mr. Waller stated not having signed any document with respect to the 29 loan, and so any obligation he had in the prior dealings with ANZ did not extend to debts owned by the virtue of the 29 loan agreement. So at this point, some of the law application that I have mentioned earlier in section 128 and section 129 will take one or two steps in. So the satisfaction of 128 is confirmed as Mr. Hodgson, one of the company directors, had previously been engaged with dealings with ANZ and was taken to be the agent of the company. In fact, Mr. Hodgson has the authority to represent the company to my contract. And in subsection 5 of section 129, it can be applied that ANZ was entitled to act on the basis that Adventure Quest had accepted in terms of 29 loan, including the provision of security by the way of existing guarantee. So when the law is applying, everything is a piece of cake. So in fact, the law is the court has come to agreement that there was no dispute between the parties as to whether the signatures was forged. The 29 loan agreement was executed on behalf of Adventure Request by Mr. Hodgson and was purported to be executed by Mr. Waller. So as we have found out how the law can be applied, but we can see the major problems existing in cases in which relating to the third parties is the definition of the one who can represent the company itself. So now I'm going to cover and give you some definition about the membership of a company who has the authorized authority to represent the company itself. The first one is the membership. So according to Corporation Act in Section 120, a person is a member of a company if he or she is identified as a member of a company on its application of registration. So membership is also extended, has also been extended to every man who agrees to become a member of a company, and those name is entered into the register of the member. So this can be done mostly by the allotment of shares and the transfers to them of shares. So as I mentioned, mostly these two types of registration and membership relating to shares. So what exactly is share? So as a economic student, we are not unfamiliar with these terms. Shares are an important source of capital and may be used to fund the operation of a company when being issued. And the members who subscribe for shares on registration or acquire shares in subsequent issues may choose to sell their shares for the future or receive dividend yearly. And maybe you may wonder, if someone just pay for the share, do they have certain rights? And can they choose for someone who violates their rights? So in fact, yes, they have 4 basic rights, including the right to vote, the right for distribution, the right for information, and the right for attracting their class of shares. And as I mentioned earlier, the members who have their rights violated can sue the company if it breaches in the duties for them. But on the other hand, if the company has something wrong to deal with, it is them that the proper person, the company it is, to take legal action to enforce its right. And I have covered through someone who has the authorized duties or responsibilities to deal with or to represent the company. So what about the upper end of the company's hierarchy? Someone in the management system, someone in control. Now I'm going to cover. So we have 6 basic definitions right here. The first one is the register office, which is a company would be liable to the penalty of if carry out a business without such a office. So in other words, the company must have a register office to which all communication and notice may be addressed. The secondly is 2 characters who are more human, the company's secretary and the directors. The secretary is responsible for bookkeeping, drawing up agendas, providing notes of meetings, and going on. The directors, on the other hand, is responsible to carry out day-to-day management, and they can be elected in the company by members of them. The directors, the numbers of directors can depend on the size of the company as well. And we have a more generalized terms, which is officers, which include the company secretary and who are liable for the breach of duties. The validity of acts of director or secretary cover that the acts of directors or secretary are valid notwithstanding any defects that may afterward be discovered in their appointments. So the term directors can include a person who is appointed to the position of directors, or a person who is not validly appointed as a director but who acts in the position of the directors. Lastly, we have the powers of directors. So as the definition I have just given you, the directors of the company can exercise all the powers of the company except for the matters that require the authority of the shareholder, like they can do hire or fire people, authorize employee to take an out loans, to enter contracts, to buy or sell, and so on. These definition may seem hard to comprehend at first, but now I'm going to give you some application in the panorama development versus Federalist Furnishing Fabrics in 1987 to make you get a clear view in these definition. So I have to say that these pay more attention to the secretary role itself. The background is that Federalist company secretary Mr. Bain hired cars from Panorama, but under the company's purpose. But actually, he used the car for personal goals. The issues rising here is that Bain has prosecuted, but the Panorama has still paid for the contracts of him. Federalists claim that it was not bound to the higher contracts because Bain never has the authority to enter a contract of this kind. But, but because of the distinctive role of a secretary, the court has held that entering a contract like this was within the usual authority of company secretary and therefore within the apparent authority of this particular secretary. In fact, Ben has the upper hand as the company secretary may not have actual, but they do have apparent authority to deal with things. So that's the end of my presentation. Next up, I will give stage to who is going to present to you the duties and the liabilities of the directors and other officers. Thank you for listening.
Thanks, Lou. And now I'm going to talk about the duties and liabilities of the directors and other officers. And my name is Win Omanu. So both common law and statute impose significant duties on the directors and other officers to act in the best interest of the companies. And according to the comments from the Royal Commission into the misconduct in the banking superannuations and financial services industry, that often entities in commercial enterprise should pursue the long-term advantages of the enterprise while obeying the law. So first of all, we need to understand about the definition of an officer. An officer can be a director or secretary or the person who makes or participates in making decisions that affect the whole or substantial part of the enterprises, has the capacity to affect significantly the corporation financial standing, and whose instructions and wishes the directors of the corporations are accustomed to act, excluding the advice. About the duties of directors or officers, there are four duties: care and diligence, good faith, improper use of position, and last but not least, improper use of information. Under Corporations Act 2001, breach of duties under Section 180 to Section 183, civil penalties apply. Officers and directors act relentlessly, dishonestly, criminal offense is committed. Next, about the duty of care and diligence mentioned in Section 180, determined by looking at the corporation's circumstances, the responsibilities that the officers had within the companies, and based on the reasonable person who have them if they have responsibilities. So, to exercise the common law duties of care and skill, the director needs to be familiar with the fundamentals of the company business, keep informed about its activities on a continuing basis, monitor corporate affairs and policies, and keep informed about its financial status by regularly reviewing its financial statement. The following two cases will identify more deeply about the duty to act with care and diligence. The case within Australian Securities and Investment Commission with Haley, case within Daniels Anderson. So this demonstrates the need of directors and officers to understand the company accounts and financial position. So in this case, ASAC launched civil penalties against the current former executive directors, the CEOs, and the CEO of the central group of companies. The defendant failed to ensure the compliance with financial reporting obligation by omitting 1.75 billion of short-term liabilities, which eventually lowered the share price of the companies. From the court beneath Justice Militant, each of the directors and officers have precious duty of care due to fail to take steps to ensure the compliance with financial obligation, which mentioned in the Corporation Act, and should have noticed the failure to include the guarantees as current liabilities in the accounts. About the case with the Cash Matters and Australian Securities and Investment Commissions, state whether the damage that the company suffered because of its breach of the financial services law were foreseeable, and therefore that the directors had the duty to take reasonable care to avoid it. So take a look into the case. The storm which is the company contraband financial services law by recommending a strategy, the Stern model, to clients for whom it was unsuitable and who suffered catastrophic losses with the global financial crisis in 2008. 300 over 14 clients have suffered significant losses once Stern collapsed. But the main point is that the directors must think beyond the financial consequences of a particular actions and consider all the possible risks. A director will not avoid liabilities merely by showing their likely profit from the contravention. As stated, the financial costs from the contravention. They must take this into account and prevent those financial consequences. About the business judgment rule mentioned in the section 180, the inherent risks take when making business decisions and acknowledge that poor outcomes do not necessarily mean that directors have breached their duties. So the best interests of the companies are usually aligned with the best interests of the company shareholder. Where they do not align, then the interest of the shareholder should take precedence over the interest of the company. About the duty to act in the good faith mentioned in section 181, exercise the power and discharge the duties in the good faith in the best interest of the corporations for all the proper purpose, so that the directors and officers act with duty of care and diligence. If they have act in the good faith and for a proper purpose, they do have a material personal interest in the decisions. They take steps which they believe to be reasonably appropriate to inform themselves about the subject of the decisions. They rationally believe that the decision is in the best interest of the corporation. About a conflict of interest mentioned in section 182 to 183. The conflict between duties of the companies and personal interests. So the conflict may arise when make up undisclosed profit from the possession in the companies compete with the companies, take up an actual or potential opportunities that properly belonged or might belong to the companies, misuse of the confidential information. So regard all covering properties, opportunities, and information belonging to the companies and unavailable for the direct use for their benefit. The director can only make use of those only if a director can demonstrate their authorities. Next, he will continue the duties of the officers.
So thank you for your very impressive presentations. Now we move to the duty to act in good faith, your position and misuse of information. So as a result of the report of the Royal Commission on Misconduct in the Banking Superannuations and Financial Services Industry, the Corporation Act was changed in 10 important ways from March 26 and 2019, as well as making some civil and criminal offense more serious in the Corporation Act. The Treasury Law amendments are in 2018. So it includes a new definition of dishonesty in Section 9 that introduced an objective test to determine whether a director's um, conduct is dishonest or not. So dishonest is now specifically defined in Section 9 as dishonest according to the standard of ordinary people. And it want to clarify the contravention of Section 184 can occur when the relevant corporation gain an advantage from the contravention. So now we move to the duty to act honestly. So the director commit an offense if they are reckless or intentionally dishonest and fail to exercise the power and duty in good faith in the corporation's best interest or for a proper purpose. So the 184 create three offenses as follows. So first, a director commit a criminal offense if they are reckless or dishonest if they are fail to exercise the power and discharge their duty in good faith and the best of fail in the best interest of the corporation or for the proper purpose. Second, the director may commit a criminal offense if they use their position dishonestly to gain an advantage for themselves or someone else to cause detriment to the corporations, or if they use their position dishonestly or recklessly to gain an advantage for themselves or someone else, or to cause or may cause detriment to the corporation under Section 184. Thus, the equivalent often lies for the misuse of company information under Section 184. The central element in it often is dishonesty. And now we move to remedies and penalties for breach of duties. The provision of Corporation Act in 2001 relating to the duty of director and other officer of the company are civil penalty provisions. The result is that if a person who violates the provision is subject to civil or with the exception of with the exception of Section 180 criminal sanction on 13 March 2019, in response to the report of Royal Commission into misconduct in the banking, superannuation, and financial services industry, 11 major changes to the corporation act were enacted, including significant increase to the maximum penalties for civil and criminal offense. So, for civil penalties, directors often 180 may be liable to civil penalties as illustrated in Figure 17 and 7. Point 7. The previous penalties were only 200,000, but today a court may order for an individual payment of a pecuniary penalties up to 1.05 million or 3 times the value of benefit derived or the detriment avoided. And for corporations, a penalties of 10.05 million or 3 times the value of the benefit derived or the detriment avoided. For the criminal sanction, a director who commit an offense under Section 184 may be liable to criminal penalties as illustrated in the figure 17.8. The penalties are fined up to 945,000 or 3 times the value of the benefit derived or the detriment avoided, or maybe they could be imprisoned for up to 15 years or both under Section 113 and 11b. So a corporation that commit a criminal offense under Section 184 may be liable to a penalty of 9.45 million or 3 times the value of the benefit derived or the detriment avoided, or they could be fined up to 10% of the annual turnover of the corporation for the next 12 months at the end of the year in which the company commit or began committing the offense. So we have a case here. So for example, after many days of Apple share being manipulated at a very high price on January 10, the chairman of the board of director of the of Apple group joint stock companies with the Trịnh Văn Quyết so 74.8 billion Apple share, but did not report and did not disclose the information before performing the transaction. So in this case, Mr. Trịnh Văn Quyết had conduct dishonestly and to gain the illicit profit for himself up to billions Vietnam dollars. So this incident caused the Vietnamese stock market to wobble and caused heavily losses to many investors. So on January 18th, 2022, the State Security Commission issued a decision to impose an administrative fine on Mr. Trịnh Văn Quyết of 1.5 billion Vietnam dong, the highest level according to the regulations. But this decision was cancelled a few days after. According to the Ministry of Public Security, Mr. Trịnh Văn Quyết behavior has enough element to constitute criminal sanction, manipulating the market securities specified in Article 211 of the Code from 2022. Regarding to the financial regimes, according to the Article 211 of the 2015 Penal Code, which regulate the crime of dealing with the security market, people who get illicit profits from 500 million Vietnam dong to less than 1.5 billion Vietnam dong will be constitute of criminal sanctions of manipulating the security market. So for causing damage, for investor with 1 to 3 billion Vietnam dong, they shall be fined from 500 million dong to 2 billion dong or imprisoned from 6 to 3 years. So the bracket penalty will be higher depending on the amount damage and the illicit gain. Violators will face maximum penalty of 7 years being imprisoned if they gain illegal profit of 1.5 billion Việt Nam đồng or cause damage to investor of 3 billion Việt Nam đồng or more. So from a background on March 29th, the Criminal Investigation Agency of the Ministry of Public Security issued a decision to prosecute the decisive factors and the arrest warrants for Mr. Jurong. At the same time, this agency also organized the auto spy and workplace of the subject involved. So Mr. Chann'el may face the maximum penalty for 7 years or for being imprisoned and fined, and maybe also being fined up to 1.5 billion Việt Nam đồng as the highest fine in the regulations. So moving next.
Okay, so thanks, Lou, for your thanks here for your presentations. And now we're coming to the disclosure of interest by directors. So subject to certain expectations, a director who has a material personal interest in a manner that related to the affairs of the companies must give the other directors notice of that interest and must not be presented while the matter is being considered by the board according to Corporation Act 2011, Section 195. However, an exception is made where the board has passed a resolution stating that the directors are satisfied that the interest director should not be disqualified. Well, for example, like an Apple board of directors are voting for a new CEO positions, and one of the candidates turn out to be one of the director's nephew, a cousin, family relations. So according to Corporation Act 2011, Section 195, that director has to inform the others of their relations and must not be allowed to vote on the CEO election unless there is an agreement of participation from other directors. Moving up to the director's duty to prevent insolvent trading. So directors, including shadows and non-executive directors, are under a duty to prevent the company from trading insolvent. This is a crucial obligation for directors because a breach of this duty has the potential to expose directors' personal liabilities for the company's debt. So the relevant provision is in Section 588 of the Corporations Act 2001, which applies where a person is a director of a company at the time when the company incurs a debt. The company is insolvent at that time or becomes insolvent by incurring the debt. Thirdly, and at the time, there are reasonable grounds for suspecting that the company is insolvent or would become insolvent. So, moving up to the defenses under the case. So there will also be several defenses available for directors in proceeding for a controversial of the sections. So there are that at the time the debt was incurred, the directors has to prove that he or she had the reasonable ground to expect and did expect that the company was solvent and would remain solvent if it incurred the debt, or believe it on a reasonable grounds that a competent and reliable person was responsible for providing adequate information to the directors about whether the company was solvent, and on the basis of that information, the directors expected that the company has solvent and would remain solvent even if it incurred the debt. Thirdly, continuously, he or she did not take part in the management of the company because of illness or some other good reason. So, last but not least, he or she must take all reasonable steps to prevent the company from incurring the debt In this context, regard may be had to any action which the director took with a view to appointing an administrators of the company. So the contributions of Section 588 has given the rights to the civil and criminal penalties discussed earlier. In addition, the compensations may be ordered in the following circumstances. So, firstly, is whether the creditors have suffered loss or damage in relation to the debt because of the company insolvency, and the court may order the director personally to pay to the company compensations equal to the amount of that loss or damage. Secondly, where the company is being wound up, the company's liquidators may bring proceedings to recover from the director personally such loss or damage as a debt due to the company's Section 588. We're coming to the last part of the presentations. So the prohibitions of insider trading. So the Corporations Act 2001 contains extensive provisions prohibiting trading with informational advantage, or as it is more commonly known, insider trading. So those provisions prohibit anyone in possession of non-public, price-sensitive information from dealing in or engaging others to deal in the share of the company. Several penalties, both civil and criminal, may be imposed for contravention, and in addition, the insider is liable to compensate the other party to a dealing in to account for any profit to the companies whose shares are traded, according to sections 1043A, 1043L. Now that's the end of my presentations. Thank you for listening.
Thanks, Big, for your part. So in my presentation, I will first go through the remaining contents in Big's section, which is the duties and liabilities of directors and officers. And then we will go through the part of how corporations do and what are the options they have when encountering difficulties reaching financial obligations. So first, let's talk about the removal of directors. The law of this is that companies may decide to make their directors resign for the jobs. So in public companies, the ones that are listed on stock exchanges such as Google, Facebook, Apple, Vingroup, might do this, might enact the law with the voting interest being equal to or over 50%. However, it's a bit different in private companies such as IKEA or Huawei. So to make the directors resign for the job, the voting interest could be 50% or more or less, depends on the company's policy. Next is the payments for retirement from office. So the company is allowed to make payments to directors at compensation for retirement from office and payments in connection with the transfer of the whole or any part of the undertaking or property of a company, only if the members of the company agree to and the relevant proposal is approved. And the final part of this section is certain types of person that are not allowed to manage corporations. So there's 6 of them. Number 1, those that are convicted of an indictable offense that affect the business related to either the decision making or the financial standing. Number 2, those that are convicted under the Corporations Act 2001 of an offense punishable by imprisonment for more than 12 months. Number 3, those that are convicted of an offense involving dishonesty which is punishable by imprisonment for at least 3 months. And also those that are committed an offense against the law of a foreign country that is punishable by imprisonment for more than 12 months. And number 5 is when the person is undischarged bankrupt, which means that when a person is financially broke, they are not allowed to run a company. And finally, those that are in the case of being executed insolvency, a personal insolvency agreement under Part X of the Bankruptcy Act 1966, or a similar law of an external territory or foreign country that has not been fully complied with. So the case you might be able to recall from the news is that is the Trong Hoàng Minh Group case. And so recently, a chairman of this company, his son and other members of the company have been arrested on March 2022. The chairman is temporarily detained to be investigated on fraud and property appropriation. And based on preliminary investigation, it's shown that he and the individuals used 3 companies to distribute unlawful bonds worth more than 10 trillion Vietnam dong, or 450 million US dollars. And currently, the vice president just announced that from this month, except for in Hanoi, other branches are closed down to reduce costs and to focusing on paying money back to investors. And for this case, I believe the chairman was in the case of number 1, that is an unethical offense affect the business in the way of its decision making, and you can see also financial standing, as it has to close down the business to reduce costs and to solve the problem. And also number 3, convicted of an offense involving dishonesty, so and which is punishable by imprisonment for at least 3 months. So obviously the chairman, he did not rightly distribute the bond. It was like some of the news call it the trash bond. So and that could cause him to be jailed for his lifetime. So it should be he should be liable for both number 1 and number 3, at least from my understanding. And next, we're gonna talk about companies in financial trouble, which is the companies, which are companies that do not have the ability to meet financial obligations to lenders as debts become due. And there are 2 options for them when this happens. Number 1 is keep the business going, and number 2, wind the business up. So let's talk about the first one, is to keep the business going. So there are also 2 ways the company can survive. Number 1 is by a third party appointed to a core company receiver. So this party is appointed to ensure the mutually beneficial agreement between the company and the creditors. So this party will first review the company's finances and operations, and after that report them to the creditors to find out the inefficiencies. I'm sorry. And then 2 scenarios are available. Number 1, if the situation is too bad, they can call for liquidating assets of the company and pay debts to its owner on a priority basis, which is generally the secure creditors first. Those are those which for those lending is collateralized with the company's assets, and then comes the unsecured creditors. And another way is that the receiver will negotiate with the creditor to create a repayment plan to restructure debts for the company. And there's an example here. In the pandemic, the demand for goods and services generally is lower than usual, for the fact that we citizens save money and spend less to prepare for, and also we run out of money, right? So the future is so unpredictable, and in this period, the Vietnamese government has instructed banks and credit institutions to restructure their payment schedules for lending amount totaling 550 trillion Vietnam dong, an equivalent to $24.3 billion. And in addition, commercial banks also waive and lower lending rates for debt worth 3,790 trillion Vietnam dong, which is equal to $167.5 billion. So as you can see, there are these two ways to restructure a financial obligation: by rescheduling the payment plan, and also by lowering the interest rate. And to stay in the business, another option for the company is voluntary administration. Voluntary administration is like an agent would like manage the company, and the company is voluntarily to give the control for this agent. And one fact is that in this form of keep doing the business, the directors and other officers of the company are not permitted to assert their roles unless approved by the new administrator. So this first option is for keep doing the business. And the not so bright scenario is that the company has to wind up. So first, let's talk about the objective. The primary objective of this action is to collect assets of the company and distribute them to creditors in certain order. Now, like we mentioned before about the secure debt and unsecured one. And there's some characteristics about winding up. So a liquidator is assigned to apply the company's assets toward the interest of the claims of creditors. In addition, the authority of directors is terminated, and if the business is still going on, it is only for the benefits of a more efficient winding up. So, and for the provision, all debts and claims proved in a winding up rank equally. And if the property of the company is insufficient to meet them in full, they are to be paid proportionately. And so there are also a type of transaction called voidable or insolvent transaction. And this there are two characteristics of them to be told a voidable transaction, to be defined as. So the first one is unfair reference, which means that if the transaction makes the unsecured creditors, the one who lends the company money without having them collateralize for their assets, So if the transaction makes this type of characters to receive more, so it's called a valuable transaction. And the second characteristic is that if this type of transaction and that a normal person wouldn't make, which could affect the benefits or detriment of the company or other parties. So, and it is called a commercial transaction. So this transaction is like the people of authority could void, make it unavailable, since these are like unfair ones and uncommercial ones. And there's two types of winding up. Number one is voluntary, and number two is compulsory by the courts. So about the compulsory winding up, it happens when the court orders a company to be winding up when it is actually be insolvent. Insolvent means that the company does not have enough cash to pay for the debts and cannot find any other ways than selling the assets to do so, to pay for the debts that is due. And the procedure for compulsory winding up is that the court make an order and assign a liquidator to be in charge. And next, the directors and the secretaries of the company would make a statement of affairs and submit them to the assigned liquidator. And after a period of time of preparation, the liquidator submit a preliminary report to the ASIC. So this is the process. And that's it for the compulsory winding up. Next, we talk about the voluntary one. And like the name said, it's winding up initiated by the company. And the duty of the liquidator in this type of winding up is that it would be applied the assets. They would apply the assets of the company based on the Corporation Act relating to preferential payments. So it's just the same. It's the order in which debts are paid from the secure creditors to the unsecure one. And the second duty of the liquidator, they have to make an account of the winding up in the process, during the process, to show the company and the creditors the process. Yeah, that's right. Yeah, so there are two duties when of the liquidator when the company decides to voluntarily winding up. And finally, it is the registration of a company. So after like the winding up, the company would resign from their registers of companies. And there are three effects that would take place when the company do this. The number one is that the company stop existing. It's so obvious, right? The next one is that the remaining security and interest of the company is vested in the ASIC. And the finally effect is that the directors must retain the books. The directors must retain the book for 3 years after the deregistration. And this is the end of our presentation. I would like to represent for our group to say thank you to you, and I wish you very joyful day. Thank you so much. Goodbye.